Stand by SOT1.
Standing.
10 seconds. Ready, rollin'. Ready, SOT1.
Ready.
In 4, 3, 2, 1. Roll in.
From legendary Uncle Studios in beautiful Southern California, welcome to another edition of Work Comp Matters, the central location for you employees, you employers, and of course, we haven't forgotten about you damn independent contractors. And now, here's this week's edition of Work Comp Matters. And it's August 7th, 12 noon straight up. Welcome to another edition of Work Comp Matters. We are brought to you by the workcompcentral.com if you want the number one location for workers' compensation in both California and around the United States. Check out the workcompcentral.com. They've got a free 7-day offer. And if you want to pick up their services, I have them. You should too. It's only $1 a day. Work Comp Matters is also brought to you by A1 Law, number one computer management system, 818-357-4120. For your no strings attached money back guarantee, also only $1 a day, A1 Law. Well, good afternoon, everybody. I'm joined as usual by the doctor, but he's not a medical doctor, Mike Zyma, my chief of staff, as well as the madman across the water, John Scalia. Oh, by the way, my name's Steve Appell. Hello. And we have a special guest, and I have been waiting for years. It is impossible to get a guest of this magnitude, and I am so proud. Admitted to the California State Bar in 1979, 35 years of experience in workers' compensation, and 20 years on the bench. What else can I say but welcome, Judge Retired Howard Goodman. It's a pleasure to have you on the show, Judge.
Morning. Thank you for having me. This should be fun.
The pleasure is mine. Now, as usual, in pre-show warm-up, I ask you, just as I ask all the guests, is there anything you want to talk about, anything you don't want to talk about, but in no way, shape, or form do I submit the questions to you? And you basically said, no holds barred. Before we get started, we'll give the contact information, but Judge Goodman is available for expert witness. He's available for ADR, alternate dispute resolution, mediation, as well as arbitration, the full gambit. So those of you in workers' comp listening, we'll give the contact information at the break, and you can contact Judge Goodman and, talk to him off the air. But I'm just going to start right from scratch, Judge. What made you decide to start practicing law, practicing attorney?
It's an interesting story. In the 60s, I literally got tired of working on cars. I decided to go to law school. I wasn't a professional mechanic. It was just keeping my act together, getting to and fro. And so I decided to go to law school. And quite frankly, I never thought I would finish law school. I finished law school. Wow. I never thought I would pass the bar. Wow, I passed the bar. No idea I'd be practicing law. And 40 years later, here I am. So.
And appreciate that. When did you decide you wanted to become a judge?
I can't say exactly. Early on, some of the judges, rest in peace. A good reason to be a judge is some of these people, if you're a judge, you don't have to appear in front of them. Okay. When I first started, I started at State Fund. Interestingly enough, I was working as an ALJ for Department of Social Services, working in downtown LA doing Medi-Cal hearings. And it was like a temporary project. And somehow I got on a list. And next thing I knew, I was working for State Fund. I had no idea I was ever going to be working in workers' comp. I worked for State Fund for about a year, I guess it was around 84, 85. Left them, went to work at several private law firms. I was house counsel for Zurich, and I did really well on the judges exam, so I decided to take the bench, so to speak.
Now, of course, for the newbies that are in workers' compensation, they're probably not familiar with the term referee because we just simply know them as workers' compensation judges. But if I'm not mistaken, back when you first became a judge, you were known as a referee. Is that correct?
No, there was a window period. In other words, nobody likes work comp judges. For some time, in some cases it's a reasoned feeling, and in some cases it's just total disrespect. They don't understand. So there was legislation that took away the term workers' comp judge. We then became referees for a bit, and now officially we're workers' compensation administrative law judges.
You said nobody likes workers' compensation judges. Are you talking about the governor, the state senators?
The administration. For some reason, okay, I was during my last stint, my last 18, 20 years as a judge, the last dozen years, I was on the board of directors of CASE, which is the union that represents administrative law judges, attorneys general, and all attorneys working for the state of California. And our big mission was to try and get a WCJ2 classification. In other words, if I did unemployment law, I could be a 2. If I was an attorney general, I could be a 4 level. And for some reason, no matter whether it was a Republican or a Democrat administration, whether it was Gray Davis or Arnold Schwarzenegger, who I must say is the worst governor in California history, I'll say that.
Thank you for saying that, but please continue.
For some reason, Department of Industrial Relations and the state's personnel people, or whatever they're called these days, just were not buying it. So you'll hear my former colleagues who do a really good job by and large. We deal with, technical areas of law. We are one of the few certified specialties in the state bar. And in fact, when I would have civil attorneys appear in my courtroom and they would see how fast and free we were with the rules of evidence, I would point out, excuse me, sir, what I do is a certified specialty. What you do isn't. Okay. So workers' comp judges render final decisions. The WCAB, the full board, review them, and it goes directly to the Court of Appeal. Other administrative law judges, such as EDD and social services, render, quote, proposed decisions, which have no force and effect until they're ratified by their respective board. So workers' comp judges were a certified specialty. We render final decisions. We deal in extremely technical issues. I have a friend whose brother's a Court of Appeal justice, and he was poo-pooing the idea, that I was called a judge. I said, something, quite frankly, Judge so-and-so, I give away more money than your average civil
Judge, I was just going to say, and I've said this on the show before many times, and a lot of civil attorneys don't get this. No matter how much they look down on the Workers' Compensation Appeals Board, I've heard it called kangaroo court. More money runs through California workers' compensation. And I want to say about 17 or 18 billion dollars, that's billion with a B, than any other field of law in California. Additionally, I've seen civil attorneys, and I'm a hearing rep, and we'll get to that in a moment. I've seen civil attorneys come into workers' compensation, come into the WCAB representing an uninsured employer, whatever. They think they're all that. And after 10 minutes, they realize they don't know jack. And I find that a lot of the workers' compensation judges really disdain, they really don't like it when a non-practicing work comp judge comes into their house, so to speak. I have retired Judge Howard Goodman as my special guest today. Guys, if you don't know, it's impossible to get judges on the show. He has been practicing, or he was in workers' compensation for 35 years as a total. He 20 years as a judge. He's now available for expert witness, alternative dispute resolution, mediation, arbitration. We're going to take a short break right now, and then we'll go back, and I want to ask him about, we can do ADR carve-outs. I want to talk about defense attorneys, applicant attorneys, and witnesses. But right now, we're going to have a short news break. Mike, John, do a couple of stories for a couple of minutes, and we'll get back with our special guest, retired Judge Howard Goodman.
I'll lead off, John.
Okay.
U.S. President Trump, on Thursday unveiled sweeping bans on U.S. transactions with Tencent, owners of WeChat, and video sharing app TikTok, which his administration has called, quote, significant threats, end quote. It's not clear to what extent the executive orders, which go into effect in 45 days, would impact WeChat's business and whether Tencent's large fleet of investments in the U.S. and other parts of the world would come as collateral. But if the ban covers U.S. companies doing businesses on WeChat, it would do more harm to U.S. firms such as Walmart and Starbucks than to Tencent, said Chen Dong-Li, a Beijing-based tech analyst. WeChat is an all-in-one mobile app that combines services familiar to Facebook, WhatsApp, Instagram, and Venmo. The so-called super app is almost essential for daily life in China and boasts more than 1 billion users. American brands, big and small, from Nike to KFC, Starbucks, and Amazon, all use WeChat's embedded mini-app programs to facilitate transactions and engage consumers in China. Trump's order sent shares of Tencent, Asia's second most valuable company, with a $686 billion market capitalization, tumbling as much as 10% on Friday. John?
Former SF medical examiner's employee sues city over Jeff Adachi autopsy dispute. Before I start reading the article, I hope some of you remember my comments about having cross-examined the deputy coroner in LA and how that office didn't resemble anything you saw on TV. And also my comments about the so-called original autopsy that was done on Jeff Epstein and the second autopsy, which was done by Howard Baden. And my point was that the offices of coroner medical examiners are a mess, and they're involved in politics. Here's the article. It's from the SF Chronicle. A former high-ranking official at the San Francisco Medical Examiner's Office is suing the city for wrongful termination, alleging he was fired after he refused to alter public defender Jeff Adachi's autopsy report on orders from city administrator Naomi Kelly. Christopher Wyrowek, a former operations director for the Medical Examiner's Office, filed a lawsuit in San Francisco Superior Court late last month, claiming he faced retaliation and was eventually terminated after spurning Kelly's demand to alter the autopsy report shortly before it was released to the public in March 2019. Wyrowek also alleges his office and work computer were ransacked by a superior in the office while he was on paternity leave in early 2019. I'm going to skip parts of it and go to the next section, which is Wyrowek claims Kelly demanded to see a copy of the autopsy report on March 22, 2019, the day it was set for public release. He alleges he refused Kelly's attempt to edit the document, told her doing so would be illegal, and released it to the public as the medical examiner's office doctors intended. The article goes on and it talks about whether or not he falsified some of his qualifications or was qualified for the office he actually occupied, which again brings into question the procedures that are going on there. So it's interesting to note that the next time you see a report from the medical examiner of some city, remember that report is probably good for your birdcage.
All right. Thank you very much, John and Mike, for our news break. My name's Steve Appell. You're dialed into Work Comp Matters. We're with our special guest, retired Judge Howard Goodman, 35 years in workers' compensation, 20 years on the bench, now acting as a expert witness, alternative dispute resolution, mediation, arbitration. Judge, I want to get to witnesses, defense attorneys, ADR, but John brings up a good point. Workers' compensation judges do have jurisdiction to find that there is fraud in the system. And in fact, back when you were a judge on the bench, even before that, when I started out in the SIU department, Special Investigations Unit. And even if we suspected something was even the slightest bit off, we would file a report with the Department of Insurance. I don't see that happening nearly as much now. But my question, I've seen judges who, of course, in their decisions, they say, I find this witness more credible than this witness, or I see this witness as really not credible at all. I've never seen a finding from a judge that claims the F word, fraud. Did you ever issue a decision that said something is fraudulent?
No, I never did. Again, my job was to be a trier of fact in a workers' comp case. If people, witnesses, especially applicants, think that this is all going to wind up in criminal action, they're intimidated. This is not the place. As far as SIU units, I remember way back when every insurance company had an SIU, that was the big thing. There was a big civil law firm, which has since gone defunct. They were the big fraud people, blah, blah, blah. Turned out they didn't know bupkis. They didn't do bupkis. And I believe a couple of the partners ultimately were convicted of fraud. So,
and also, I believe we mentioned a few minutes ago something, or you mentioned about a death case. Still on the books, workers' compensation judges are vested still with the authority to order an autopsy and actually an exhumation. Yes, I've never seen that done either. Did you ever come close to doing that?
No, not really. And we're also authorized to do body attachments. The last time that was done was in 1947, I believe. So,
a body attachment?
In other words, if somebody doesn't show up, pursuant to a valid subpoena in my court, when I was on the bench, I could theoretically have the local gendarmerie go out and pick the person up.
Judges are also authorized to do writs of attachment. That is still in the code as well.
Yeah.
During the first segment, Mike brought up alternative dispute resolution, and that is currently a field that you are in. Why don't you take a couple of minutes and talk about the ADR process and your involvement? Okay.
ADR, alternative dispute resolution. The main code sections are Labor Code Section 3201.5 and 3201.7. The carve-outs I do, about 80% of my total work is ADR work for trade unions, crafts union, operating engineers unions, and janitorial unions. Now, basically, for a union to be subject to ADR, they will enter into a memorandum of understanding. The union will with the various employers. The administrative director has to approve it. And basically, it is a much more streamlined system. As I tell injured workers, I did my first in-person arbitration yesterday in several months. And I will tell the injured worker that based upon your union contract, work injuries are subject to what's called alternative dispute resolution, which is a smaller system within the workers' compensation system. We have all the powers and all the duties. However, we are much more streamlined. I had 3 cases yesterday, an arbitration and 2 mediations, and I was able to get through all of them. I got the liens on the arbitration resolved. I got 1 case settled, and actually I got both cases settled. The point is, if I was at the WCAB with, I don't know how many MSCs they do these days. I don't know, 40, 50, 60. All I could do was shuffle them off to the next step.
And also, pardon me for interrupting, arbitrations are not continued. I mean, it's in the rules and regs, workers' comp, continuance is only with good cause. But in the day and age of COVID now and such like that, we're seeing many, many continuances.
Yeah, we see the mandate is to get them moving. The various ombuds people I work for, they will never tell me how to decide a case, but they want me to keep them moving. Almost, I will give continuances, but very few. In arbitration, we have attorneys. Oh, well, I don't have to show. Oh, yes, you do. I have all the labor code. I forget which section. The labor code gives the arbitrator all the powers and duties of a workers' compensation judge. There are two things you can't do. As an arbitrator, you can't order the exhumation, and you can't refer cases to an IME. But other than that, if you don't show up, I will sanction you. And that's enough of a threat. So basically, we get things done. Like I said, I had three cases yesterday, an arbitration lien trial and 2 mediations, and they were all settled. If I was a sitting judge at the board, would have gotten nothing done.
I mentioned a minute ago about COVID-19, and the cases right now are being handled all telephonically. I got it hot off the press yesterday that the Workers' Compensation Appeals Board across the state will start doing video trials and or training the judges August 17th. But prior to COVID, at least to the best of my knowledge, the only thing even like that we referred to as a Skype trial. And most of the time it involved where an applicant was out of state for whatever reason, could not travel. I believe that you had to get permission or petition the presiding judge to actually do a Skype trial. And that facility has been in place for a couple of years. Did you ever do a Skype trial?
No, I never have. I've only done, since COVID, I've only done one remote trial. It was an arbitration. It was just audio. It was very quick. The applicant, for some reason, elected not to testify, which is too bad because I ultimately had to decide the case on the cold record. I have no idea if this guy was credible or not. I had to go through all the medical. I decided basically. Well,
it wasn't a denied case, was it?
No, but it was, They claimed, the employer claimed it was a first aid injury. The guy fell. He was a construction worker. He fell off a beam onto the floor and hit himself. Okay. The question was, how badly did he injure himself? How come he complained to one doctor about one body part the day before the injury? So it wasn't denied. I ultimately found no permanent disability. I mean, I really, his doctor found a ton of permanent disability, but I just couldn't buy it. So, I wasn't a take nothing because I found injury, but I found no permanent disability. So I'm waiting for the recon. And interestingly enough, for those practitioners who do ADR, please remember any petitions for reconsideration must be filed directly with the WCAB in San Francisco, not the local district office, not the San Francisco district office, the actual commissioners at either their PO box or on the 9th floor. When I first started doing this, 3 out of 5 petitions for reconsideration were filed
at the local level.
And they were denied by operational law. Boom, the 15, your 25 days is gone and they're not being filed. So,
Judge Goodman, we've got a few minutes left before our second break, and you brought up some examples of your being a judge cases you've had. What's the most memorable case or trial you ever presided over? You don't have to name names, just the facts of the case, and why was it so memorable to you?
Okay, this is my flu shot case, which I guess is now germane. The applicant was a truck driver, working for a company. They had a flu shot clinic at work. He stopped and got the flu shot. 2 weeks later, the man is paralyzed from the waist down. Okay. There is a condition called transverse myelitis, which may be due to an allergy to eggs. 1 in maybe 50 million people are subject to this. So ultimately, the defense doctor said, yes, it was reasonably possible. And then 2 weeks later said, no, it can't happen. So anyhow, I found injury. I certainly got a recon. I was upheld. Then the insurance company went belly up. I gave the guy 100% and, 24/7 medical care. The tragic part was the insurance company went belly up. SIGA took over. And then SIGA, because the civil attorney screwed up the third party case by not getting credit or not getting a waiver of credit, SIGA then went after this guy's 24/7. And ultimately, over the course of several years, this was ultimately the last case I tried. And I denied SIGA's credit. I don't know if I was intellectually honest. Ultimately, 3 years after I left the the WCAB overturned me. And thank goodness my name was not on the decision, because I was not there to write the recommendation. Anyhow, long story short, a couple of years after this, I was at the State Bar Convention, and the feds have what they call the vaccine reimbursement or whatever. They had a booth there, and I stopped to ask the guy at the booth, and before I got 5 words out of my mouth, he said, "Oh, transverse myelitis." So I immediately knew I made the right decision. So, anyhow.
And that, I'm sure you did. My name's Steve Appell. You're dialed into Work Comp Matters. We're speaking with our special guest, retired Judge Howard Goodman, workers' compensation practitioner for 35 years, sitting on the bench for 20 years, now available for expert witness, alternative dispute resolution, mediation, arbitration. We'll be back with him in a couple of minutes after a news break. We are, of course, brought to you by workcompcentral.com. If you want the #1 location for workers' compensation in both California and around the United States, check out workcompcentral.com. Work Comp Matters is also brought to you by A1 Law, #1 computer management system, 818-357-4120. We'll be back with our special guest, retired Judge Howard Goodman, after a couple of news stories. Good, take it away, guys.
The death toll from the coronavirus in California surpassed 10,000 folks on Thursday, a mark that underscores how a state that was once hailed as a pandemic success story is now struggling to slow outbreaks. As of Friday morning, California had at least 541,494 confirmed cases and 10,028 deaths. Adding to the problem, the virus is now severely affecting rural and agricultural areas. Quote, "The epidemic is moving from urban Latino populations to rural Latino populations," end quote, said Dr. George Rutherford, epidemiologist and infectious disease expert at UC San Francisco. California reported 202 new deaths from the coronavirus on Wednesday, the second most of any day since the start of the pandemic. The state set a record last Friday with 219 COVID-19 fatalities reported. This development at the overall state level happened as the number of deaths in the central San Joaquin Valley topped 500. John?
Yeah, the next article has to do with Oregon decriminalizing drugs. And the reason I'm reading it is because it goes directly to the Black Lives Matter movement and the misnamed defund the police. Actually, defunding the police is not defunding the police. Defunding the police is a misnomer. What it means is allocating money that the police have, and instead of letting the police do things that police shouldn't be doing, having the people who are actually experts in the area do it. Anyway, here's the article from AOL. Oregon could become the first state to decriminalize drugs. Nearly 2 people die every day from drug overdoses in Oregon. 1 out of 11 Oregonians suffer from addiction. The state also ranks last in the nation among states in drug treatment and recovery services for adults, according to a federal government survey on national drug use. This fall, it might become the first state in the nation to decriminalize drug possession. Initiative 44, which will be on the ballot in November, would end the criminalization recovery and harm reduction program outside of the criminal justice system. The fine could be waived if the recipient chooses to undergo a voluntary treatment assessment under the new system. What we're trying to do is put drug use back where it belongs, which is under that public health scope, and completely remove it from the criminal justice system, said Matt Sutton, a spokesman for the Drug Policy Alliance, a national harm reduction nonprofit backing Initiative 44.
All right,
folks, is what it's all about.
Thank you, John, and thank you, Mike. My name is Steve Appell. You're dialed into Work Comp Matters. We're with our special guest, retired Judge Howard Goodman, in workers' compensation for 35 years, sitting on the bench for 20 years, currently available for expert witness, alternative dispute resolution, mediation, and arbitration. Judge, I wanted to ask you, when you were on the bench, or maybe even now, and I know that judges talk about the practitioners, and of course, us practitioners talk about the judges. Firstly, is there a common denominator that the judges feel the difference between hearing representatives and attorneys, or is it just based on the individual person?
It's a combination of both. We have some hearing reps that if I didn't know they were a hearing rep, I would swear they were an attorney. Then you have some hearing reps who quote work for an attorney, but in reality, they're just fronting for the attorney. So I have mixed feelings about having hearing reps in the system. So sometimes they do a good job. Originally, hearing reps, the theory was, well, in order for people to get representation, they may have to avail themselves of non-attorneys. I don't know if that's the case anymore.
What are the good and bad qualities that you saw and look for in an applicant attorney and a defense attorney, or is it the same thing?
It's a little different. With a defense attorney, first of all, both applicant and defense attorneys, if you don't know your file when you appear in front of me, it's going to be 50 miles of bad road, okay? If you don't know your file and then take an unreasonable position, it's going to be 100 miles of bad road. So the bottom line is know your file.
Be prepared and know your file.
Now, taking an unreasonable position doesn't mean trying to get as much money for your client as an applicant attorney or trying to pay as little as you can as a defense attorney. So, but don't say stupid things, and never, ever, ever say to the judge, well, I'm going to file a petition for a reconsideration. Go file your petition. Don't threaten it. Threatening litigation is a violation of the rules of professional responsibility.
Let's talk about recons for a moment. They track, I want to say the Workers' Compensation Commission or whatever judicial board it is. I believe they track how many decisions and how many appeals that you get. Is that true? Are you judged somewhat on that? Is a judge judged on that?
Not that I know of. Now, they do, I don't know if they still do, but, with Eames, but we used to have what's called a 60-day list. If you had a case pending more than 60 days, it showed up on this list. And that they track. I have no idea if they track appeals, reversals, et cetera, et cetera.
I don't know if they were doing it back when you were on the bench, but I know for 100% certainty now that every time a judge gets his check every 2 weeks, he's required to sign a declaration under penalty of perjury that he has no decisions more than 90 days out. Is that your understanding?
Yeah. Okay. Judges get paid once a month.
Oh, okay.
They do, in order to get your paycheck, you need to sign an affidavit, as you correctly, that you have no cases pending more than 90 days. There are some judges who, making a decision is the hardest thing in their life. I'm more than 90 days. I won't sign my affidavit. I won't get my paycheck. Okay. And sometimes this goes on for month after month. And they figure since I'm not perjuring myself, no, you're not doing your damn job. Your job is to decide the cases. Okay. So just because you're not signing your affidavit doesn't mean you're doing your job. Conversely, if you sign your affidavit falsely, you will likely get fired. And rightly so. And quite frankly, if the administration doesn't like you, you better keep up the 90-day rule. Now, there's also the 30-day rule. Now, they don't really enforce the 30-day rule.
What is the 30-day rule?
You're supposed to make findings of fact within 30 days. I thought
it was 90, which is why they have the 90. I guess.
No, yeah, the 90. A judge has to certify 90, but I think it's labor code 5303, whatever. A judge is supposed to make findings of fact and evidence within 30 days. Okay. I don't know, even though remember the labor code section. I haven't even unwrapped my 2021. But
judges have always told me that it is their job to expedite benefits to the injured worker. But in addition to that, of course, we have liens, we have 132A, and we have S&W, serious and willful. Liens always take the back seat to everything. Well, and you mentioned in the last segment that you resolved all the liens, and traditionally liens have just been backed up. Is that just the way the system works?
You're talking about the ADR system or the regular system?
No, the regular Workers' Compensation Appeals Board. I
believe I haven't seen the latest policy and procedural matter, but there was an official prioritization of what a judge is supposed to do. Continuing testimony cases, have first priority. Expedited hearings may take priority over that. So as far as I recall, lien trials took least priority.
What about?
Can I chip in on that?
Yes, John. As soon as I ask the one follow-up question, then you can. What about 132A, which is discrimination for filing a case, and serious and willful? Employer was put on notice or should have known that a situation was dangerous and an injury occurred.
Those have, I believe, those have the same priority as your case in chief. My big 132A case was Curry versus MTA, which awarded prejudgment interest on 132As. The WCAB, interestingly enough, reversed me and chastised me. Larry Drayson was applicant's attorney. I initially decided against Mr. Drayson. I was stopped in traffic one day on my way to the board on Pacific Coast Highway, and I said, you know something, he's right. So I rescinded my decision. I found the prejudgment interest. WCAB reversed me and chastised me. The California Supreme Court upheld me unanimously. So anyhow, that's my big war story.
John Scalia, you wanted to ask something or make a comment. Go for it.
Yeah, back when I began practicing, which was actually even before Judge Goodman started, back in the Paleolithic age, liens were resolved at the same time as the case in chief, and there was never. One of the reasons was that there usually were only 2 or 3 liens, but a judge wouldn't even approve a settlement at the board unless the defense attorney went to the phone. Back then, we didn't have cell phones. Unless the defense attorney went to the phone and got settlement agreements on all the liens. And so all the cases, there was no lien backlog because all the liens were being resolved at the time. The 2 things that created the lien backlog were the fact that some applicants' attorneys decided that they were going to have 10 medical legal examinations plus self-procured, and the fact that the judges decided that they could go ahead and approve settlements without having to bother to get the people to resolve the liens, and they could just put it into Never Never Land. And so that, in my opinion, is what has resulted in this humongous backlog of liens.
And thank you for that. Mike Zyma, did you have a question for Judge Howard Goodman?
Judge, did you ever get really angry at a party appearing before you at the WCAB?
Good question. And Judge Goodman, you throw a file, throw a punch on the bench. I've seen files thrown before.
No, never throw a file. Sometimes people really piss you off. And again, I'm using, colorful language. Again, because they don't know their file and they're taking unreasonable positions. And I'm going to file this. I'm going to do that. Okay. The only problem I ever had with that is some attorney, he didn't show up or whatever. And, at a hearing, and I took action. And in his response, he said, well, sometimes Judge Goodman doesn't show up either. And I ran into the guy in the hallway and I said, that makes me angry. Well, he filed a complaint against me, alleged that I poked him in the chest and raised my voice. I never touched this guy, but I was investigated for about 3 years over that. So no, there was a judge in Norwalk who did throw files, and he was demoted for a pay grade for that. So you can't do that. It's not your job.
We got the last break and the last segment coming up in a couple of minutes. The main job, as I said earlier, of a workers' compensation judge is to provide injured workers with expedited benefits and, of course, approve the settlements. Now, I've never, ever seen a judge not approve a settlement and set it for adequacy because the injured worker was getting too much money. But certainly I've had files that have been set for adequacy because the judge didn't think the applicant was getting enough money. What's your take on, if both parties are represented, everybody wants the settlement? What's your take on judges setting cases for adequacy? When is it necessary? When is it not?
I tended to look, well, first of all, some judges will not approve a 0% stip just on principle. That makes no sense to me. Just because you stubbed your toe at work, you want to stip because, you might need toe surgery. Okay. I tend to look at, really big settlements, $100,000, $2-3 million settlements, much more closely than I look at a $5,000 nuisance settlement with a Thomas. First thing I look at, who are the counsel? The same judge who allegedly threw files at people, his standard was, well, when I was an attorney, I could have done better. That's not the standard. The standard is it adequate? First thing you look at are the parties. At the risk of mentioning names, if Marv Shapiro, rest in peace, brought me a CNR, I don't care what it was, I'm going to approve it.
And I'm going to stop you right there. Okay, Rose, Klein, and Mara is basically the standard in workers' compensation applicant-plaintiff law going back 50 years. And that's interesting because we know judges are supposed to be impartial, but you just said something really striking, that the competency or the reputation or the knowledge you have of this attorney is going to affect whether or not you approve a settlement. Please continue.
Yeah, now there are some attorneys, very marginal people, some hearing reps who work for marginal attorneys. I don't see that in ADR usually. I'm going to go through those with a fine-tooth comb. Let's see what's going on. Now, I understand there's a slew of CNRs going through certain boards, a few $1,000s with no medicals, and I understand some of the judges are scrutinizing them, more thoroughly. Again, I look at the practitioners. Again, I'm more likely to scrutinize a high dollar value compromise and release more than I am a low dollar value. Workers' comp is a volume business. The parties, again, if they're competent attorneys, at Marina Del Rey, we used to have what we call the 5 families. These were 5 firms
sure.
That had the best practitioners. And, if we got a CNR or a stip from one of the 5 families and it was a low amount, there's probably something going on behind the scenes. There was a judge in Los Angeles who's gone now who there was a case where, she didn't think the applicant was getting enough money. She set it for adequacy, did a trial, wound up giving the applicant a take nothing. How dare she?
Oh my goodness. We've got one segment left. My name's Steve Appell. You're dialed into Work Comp Matters. We're with my very special guest, retired Judge Howard Goodman, 35 years in work comp, 20 years on the bench, now doing expert witness, ADR, mediation, and arbitration. We're going to come back with the last segment, but Mike and John each have a news story. Take it away, guys.
For struggling San Francisco restaurants, adding outdoor dining means facing a variety of elements on the city's streets, including a homelessness crisis that's worsened during the pandemic. In the case of one fine dining restaurant, it means enclosing diners in transparent geodesic domes on the plaza outside its doors. On Wednesday, Hashiri, a Michelin-starred Japanese restaurant, began seating diners inside these domes, or garden igloos, structures covered in clear plastic that are sometimes employed by rooftop bars during winter in New York or Chicago, for a $200 per person kaiseki or omakase sushi dinner. John?
This is from the LA Times. Facing a wave of evictions, California is about to make thousands of kids homeless. Things weren't great before COVID-19, but at least only about 570 families, hungry, broken, on the brink of homelessness, needed help from the volunteers at St. Joseph Center in LA. Today, that number is about 860. A month from now, it could be in the thousands or even more. California is rapidly approaching what has been dubbed the, quote, eviction cliff, close quote, or the point where true protection from being evicted during the pandemic will fall away, at least for a short time. If that happens, as many as 1 million families across the state, some 365,000 in LA County alone, could find themselves at risk of being forced out of their homes, perhaps as soon as September. It would be on the order of a big earthquake on the San Andreas, said retired law professor Gary Blasi, who published a study on the topic in May for the UCLA Luskin Institute on Inequality and Democracy. It'll be a man-made version of San Andreas, except the buildings will still be standing. It's just the people that will be on the street. If I could add a comment to Judge Goodman's last little note there.
Well, sure. Here, let me just set it up. Hang on a second, and then we'll do that. My name's Steve Appell. You're dialed into Work Comp Matters. We're brought to you by the workcompcentral.com, number one location for workers' compensation in California and around the United States. Work Comp Matters is also brought to you by A1 Law, number one computer management system, 818-357-4120. We're with my special guest, retired Judge Howard Goodman, 35 years in workers' compensation, 20 years on the bench, available for expert witness, ADR, mediation, arbitration. John, go ahead.
Yeah, I had some personal experience with what Judge Goodman's talking about. It was really funny. I was representing an applicant, and I had a settlement, and it was in front of Judge Caton in Santa Monica, who Gil's a great guy and a good judge. And he started asking me a bunch of questions about the settlement. I thought, wow, this is really odd, you know. And after about 3 or 4 questions, Gil looks up from his desk and he looks at me and he says, "What am I doing?" He says, "I've got competent counsel in front of me and I'm asking questions about the CNR." He says, "Here." And he signed it and said, "Get out of here."
Mike, did you have a comment, question in mind before I finish?
Well, I'd like to lighten it up a little bit.
Well, actually, I was going to do that. How about if I lighten it up a little bit, and then if I miss something, you can go for it, okay? So, Judge Goodman, here's the lightened up part of the show. Number 1, what does a judge eat for breakfast?
I had oatmeal this morning.
Okay. Let me give some full disclosure. Mike, you and Mike either used to work together, you used to represent him. He told me that you authored some type of journal or book called What Does a Judge Eat for Breakfast?
I may have. I've known Mike a long time. So,
all right. Well, there goes that one, number 1. Number 2, I understand that you met one of the most famous rock stars of all time, Mick Jagger. Do you remember meeting Mick? Please tell us how did you get to meet Mick Jagger?
I was living in Topanga Canyon, living an alternative lifestyle. My next door neighbor was Alice Cooper's group that was getting formed. One night, my roommate and I tagged along. They went to Frank Zappa was living in the log cabin in Laurel Canyon, and Mick Jagger and Marianne Faithfull were there. Needless to say, I sat in a corner trying not to gape, and it was very interesting. It was probably 1967. So.
And for those of you that don't know, I recently saw it making the cable run on, I don't know if it's TMC or HBO, is a show literally called, quote, Laurel Canyon, close quote. And I believe it's a 2-part documentary on what it was like living in the 60s and the 70s in Laurel Canyon. Mike, go ahead.
I have another one. Judge, did you ever see the Flying Burrito Brothers at the Palomino Club in North Hollywood?
I believe I did. Let me tell you another story. I had a friend who had a group called Easy Money that played at the Palomino. The night before the last day of the bar exam, they left some tickets for me. I attribute passing the bar exam to the fact that I did not go see Easy Money at the Palomino Club. So,
Judge,
and I'd also
go ahead, Mike. Go ahead, Mike.
Sorry, that Laurel Canyon documentary is absolutely extraordinary. It's a rapture. Anyway, go ahead.
Oh, yeah, that was good. I've seen that. I lived in Topanga Canyon. Okay. My next door neighbor was dating Charlie Manson. I remember looking out the window of my cabin one day, and the LA Sheriff Department and Susan Atkins were coming to visit my next door neighbor about this guy, Charlie, who lived at the other end of Topanga Canyon. So.
Yeah, he lived up northern Chatsworth or whatnot.
Yeah.
Judge, What's the most interesting thing that you have worn under your robe? And what is the most interesting thing you saw another judge wore or not worn under the robe?
I can't say I really wore anything. The nice thing about wearing a robe is I never had to have a sport coat. I always dressed the minimal. I guess the most unusual thing is I was on a jury in Superior Court in Malibu, and the Superior Court judge, under his robe, he was wearing a plaid shirt. So I can nobody without pants, nobody nothing like newscasters. These days with Zoom newscasters, they don't realize that the camera can see that they're sitting around in their underwear. In fact, I better look down and see what I'm wearing. Okay.
Well, as I gave you advance notice, this is a radio podcast, so whatever you're wearing, no one's going to see it. Judge Goodman, where do you draw the line between a practicing attorney going out with the judges for lunch or socializing for drinks after work, and where it becomes a conflict of interest to socialize with the practitioners that appear before you?
Okay, before this all hit the fan, on most Tuesdays, I would join the Van Nuys judges for pizza. We would walk to Pizza Rev. Occasionally, an attorney, Judge Rasp, would join us. As long as we don't talk about specific cases, I refused now, and I refused back then, to let the administration tell me who my friends were. I'm not taking free dinners. I'm not taking gifts. Now, when I first left the bench, I was doing depositions for a couple of firms. And since they have ADR cases, the ombudsperson, asked me to not do depositions. And, she was correct. So I don't do depositions anymore. But as far as who my friends are, as far as the friends of the judges, as long as there's no money changing hands or, whatever, if I've known somebody for 20 years, just because I'm a judge, I'm going to see this person. I can go to dinner at their house. I'm going to invite them to dinner at my house.
Some of our, one moment. Some of our newer practitioners, I'm sure, are familiar with Labor Code 4906G about any incentive given to or received from doctors for medical evidence, for medical evaluations. But back when you were practicing, that was not a code. And it was quite often that both defense attorneys and applicant attorneys would give doctors gifts. The doctors would come and give the practitioners and the claims examiners gifts. Of course, that doesn't go on anymore. And I know that certain insurance companies, TPAs, have a $25 limit on any type of gift from anybody. Some you're not allowed to accept them at all. What's the most extravagant or expensive gift that you ever got as a practice? I'm assuming it's as a practicing attorney. I'm assuming you didn't get one as a judge.
As a defense attorney, I remember I worked for a defense firm in Glendale, and we went over there once for a firm meeting, and some TVs. Okay, I believe I left that firm shortly thereafter, so they kept my color TV. But
TVs, you dropped out a little bit there, but TVs, got a TV. Yeah. How about that? Well, we are about at the end. John Scalia, do you have a lasting comment, burning desire?
No, I just say thanks for appearing on the show, Judge Goodman, and it was always a pleasure to appear in front of you. So maybe you'll come back and do this again.
I'd be happy to.
Oh, thank you, Mike Zyma. Lasting question, burning desire.
It was a pleasure to work with Howard. It was a pleasure to be represented by Howard. It was a pleasure to appear before Judge Goodman. Judge Goodman, my good friend, thank you.
Thank you, Michael.
Of course, my special guest has been retired Judge Howard Goodman, 35 years in workers' compensation, 20 years on the bench, currently available for expert witness, ADR, mediation, and arbitration. Judge Goodman, take a minute before we close the show. Give your contact information, email, phone number, Facebook, whatever you want. Go for it.
Okay. Best way to get a hold of me is my cell phone, area code 818-522-2603. That's 818-522-2603. If you're not on my contact list, it will go straight to voicemail, but I promise you I will return your call. My email is HG, as in George, EEP, as in Paul, at earthlink.net. So it's HG at earthlink.net. You can get if you don't have a pencil, you can get my contact information from my state bar website. But the best way is my phone number, 818-522-2603. ADR, expert witness, private arbitrations. I'm very good on contribution. I'm a pretty sharp guy. So
I would say a very sharp guy. And once again, thank you very much for spending your valuable time coming on. And we would love to have you on again. Retired Judge Howard Goodman. Thank you very much. For Mike Zyma, for John Scalia, for Scott Walton of Uncle Studio, all the good people back at WorkCompCentral and A1 Law, and of course, retired Judge Howard Goodman. My name is Steve Appell. We'll see you again Monday at noon for another edition of Work Comp Matters. Stick around, judges.